Members of the jury, I will now read the verdicts as they will appear in the permanent records of the 4th Judicial District. State of Minnesota, County of Hennepin, District Court, 4th Judicial District. State of Minnesota Plaintiff versus Derek Michael Chauvin, Defendant. Verdict, count 1. Court file number 27, CR 20-12646. We, the jury, in the above entitled matter as to count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. This verdict agreed to this 20th day of April, 2021 at 1:44 p.m. Signed, juror foreperson, juror number 19. Same caption, verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. This verdict agreed to this 20th day of April, 2021 at 1:45 p.m. Signed by jury foreperson, juror number 19. Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty. This verdict agreed to this 20th day of April, 2021 at 1:45 p.m. Jury foreperson 019. Members of the jury, I'm now going to ask you individually if these are your true and correct verdicts. Please respond yes or no. Juror number 2, are these your true and correct verdicts?
Yes.
Juror number 9, are these your true and correct verdicts?
Yes.
Juror number 19, are these your true and correct verdicts?
Yes.
Juror number 27, are these your true and correct verdicts?
Yes.
Juror number 44, are these your true and correct verdicts?
Yes.
Juror number 52, are these your true and correct verdicts?
Yes.
Juror number 55, are these your true and correct verdicts?
Yes.
Juror number 79, are these your true and correct verdicts?
Yes.
Juror number 85, are these your true and correct verdicts?
Yes.
Juror number 89, are these your true and correct verdicts?
Yes.
Juror number 91, are these your true and correct verdicts?
Yes.
Juror number 92, are these your true and correct verdicts?
Yes.
Are these your verdicts? So say you one, so say you all.
Yes.
Members of the jury, I find that the verdicts as read reflect the will of the jury and will be filed accordingly. I have to thank you on behalf of the people of the state of Minnesota for not only jury service, but heavy duty jury service. What I'm going to ask you to do now is to follow the deputy back into your usual room, and I will join you in a few minutes to answer questions and to advise you further. So all rise for the jury.
Okay. All right. Guilty on all charges, as I thought would happen. Now the work begins. Now the real work begins. You hear the cheering outside the courthouse. People are elated. I'm emotional in a different way, because it took the kitchen sink, as Don Calloway, as we were talking about, took the whole entire kitchen sink, a video, 9 minutes and 29 minutes. It took a 8-year-old, a 17-year-old, a firefighter, EMT worker. It took the police chief of Minneapolis. It took several other police officers. It took a pulmonologist, it took a cardiologist. It took all of these medical professionals. It took everything and the ancestors themselves to come down, and the whole entire world, actually, because this is the case that made Germany and Africa and Great Britain and Australia, New Zealand, places all over the world, far reaches, get to the streets in protest of something so heinous and ugly. Anything other than a guilty verdict, and that flag in which is flown in this country, the very oath upon which many of us pledge allegiance to, would be meaningless. This country would no longer exist. I believe that if there was a not guilty on any of these charges, to be honest with you. All charges, the first, second degree carries a 40-year sentence. The third degree carries a 25-year sentence. The manslaughter carries a 10. The judge should run them, was it concurrently? Yes. Is that what Don, the lawyer, consecutively or concurrently?
Consecutively is back to back, concurrently is together. He probably would have got concurrently, but he probably will get concurrently, but TBD, we don't know. And if you give somebody a long enough sentence, then it can all be concurrent. If he gets the 25 plus years he deserves. The
40 is second degree comes with 40.
Yeah. If he gets the full 40 years, then it will be fine if they're not consecutive, because I guess theoretically that would be 120 altogether.
Well, I mean, the rapist and I forgot who what state that was, the man that raped like 16 plus women, he got 100 and plus years.
Oh, no doubt.
Yeah, so I think Holzclaw, Daniel Holzclaw.
There's no doubt that there's precedent for the consecutive sentences, and that happens on occasion. It all depends on this judge's view of, criminal sentencing, which we don't know. But I think the point is that if he gets the max, which he should, on a concurrent sentence, that should be enough. That should be his natural life.
No, it should not be enough. I mean, people live a long time. Bernie Madoff got 100 and something years. I think it sends a message to run these all one after the other. Run them back to back to back. Yes. And I think it sends a message clearly, and it will show about this judge. It'll show where this judge is sitting, because the case, and we talked with Angie Porter, who is in Minnesota right now, the University of Minnesota law professor, who is right now on public radio there because she had a commitment to be there with the people in Minneapolis in this space to have this discussion today, and I honor that. We talked about what that actually means, to sit in this space right now. And 866-801-8255. I'm gonna back up. The measure in which we have to really approach this, Don and Drew, to be gleeful. Again, it took them making him to be a bad apple, which was the defense at the end. This is not an indictment of policing. This is not an indictment of police. This is one person. This is one bad apple. This is one person that did this bad thing. This is not, they're good police. The police are good. That was the closing argument, right? That the prosecution laid forth. And I thought, at the time, that was the only way they could win this, which sucks, because this should be an indictment of this system. Derek Chauvin did not act as a lone wolf. He did not act as a bad apple. He acted as the system was designed for him to behave, as if he is above the law. And we keep seeing it. And the one person that did go to jail for those 100 plus years, Daniel Holzclaw, because the victim survived, right? But there's no justice for Breonna Taylor.
Yep.
Amber Geiger is going to be filing definitely is going to be on appeal, but Botham Jean was in his house, watching television, minding his black happy business. And
the black judge hugged the woman.
Hugged her, came off the bench and hugged this woman. Like you tell that to Lieutenant Nazario, who was enjoying his nice SUV, brand new, dog in the back. Pulled over and he's like, I don't trust these cops. Let me go to a well-lit area. Thank God he did. We got that all on film. Turned on his camera and still got pepper sprayed.
At close range. With his uniform on.
Right. So, yay. All 3 counts guilty. Anything less than that would be a problem. Let's just be clear about that. But this is not a solution. So.
This problem is by no means solved.
Yeah, this is not a solution. And that goes to the point that even here, with the best possible outcome, with the best possible sentence, which is an LWOP, life without parole, if this goes as best as it could possibly go, there's no justice here. There's only accountability. Justice would be George Floyd alive, raising his kid. So, I hate to be that skeptic or throw water on the scenario, but I just don't like people saying, we got justice. No, we really didn't. We saw the rare instance of accountability. But this certainly is not justice.
Yeah.
Let me welcome in.
We still haven't seen the sentence yet. You know what I mean? We still got to wait 8 weeks until the sentencing actually happens, right? And so, I agree that this problem has not been solved by any stretch of the imagination. I go back to the point, Karen, that while I'm glad that this is the outcome, I'm still concerned that this is now the bar to which we have to meet to get a conviction of when police kill unarmed Black folks, right, in this country. Like, if this is the bar that we have to hit, it's like it goes back to when people think that the litmus test for racism is the N-word, right? There's a whole lot of racism that is enacted upon Black folks verbally and otherwise beyond being called the N-word. That ain't the litmus test for racism. And this should not be the bar that you have to have 9 minutes of video. Everybody has to be at home during a pandemic to see it play out on the news 15 times a day. At one point, I counted on watching cable news. It should not be that this is the bar that's set, that you have 15 people who actually saw it, who were not members of law enforcement, right? That's the part where I am concerned about.
That's a great point. And I've kind of consistently tried to make the argument, listen, when you get pulled over or when you have an encounter with a police officer as a Black man, there is and a Black woman as well, there is such a broad range of outcomes. And there is such a broad range of undesirable and unacceptable and abuse-based outcomes, from talking to us disrespectfully, from detaining us to an unreasonable amount of time so we can't get going with our day, from intimidation and all of that shit. There's such a broad range, and death is at the far end of it, but all of it is fundamentally unacceptable. So you're absolutely right that in order to get a conviction for police abuses, if we have to meet a bar of a globally recognized lynching video and 15 credible eyewitnesses, that's not really a victory. You make an excellent point about level setting.
Let's welcome in. Let's welcome in. She was here yesterday, and also want to shout out Keith Ellison, because I believe the local DA, wasn't going to bring this case. This was his genius. I saw his fingerprints all over it. Low-key had conversations with him. I don't talk much about my relationships with people, but I was confident because the strategy had to be what the strategy is. And I want to make sure the experts are here to have these conversations, which is why I have Drew and Don Calloway. But Professor Angie Porter has been on the ground in Minnesota this whole way, and every Monday has been joining us to talk about this trial. So let me welcome her in. Professor Angie Porter, welcome.
Thank you, Professor Hunter. And I'm listening a little bit. I think we can be happy today. I think we can let ourselves go and be happy today. Of course, we know there's a lot of work to do. All of us are thinking Black brains. We know what it is. But I encourage folks to take a second and just be happy, because we've been waiting with bated breath about this particular case. It has come to a conclusion. Yes, there will be things that happen afterwards, but we can get there when we get there. It is incredibly important to have this conviction, incredibly important, and to have it on all 3 counts. And so give yourselves time to celebrate. Then let's get back to work tomorrow. But I encourage us for our mental health and for our collective victory here to allow yourself to be happy, for real.
I thank you for that, because I don't know if anybody else in this room, but I had butterflies and some heart palpitations as I was waiting for the judge to read it, and saying a little prayer. Also, because all three had to be guilty. Mm-hmm. All 3 had to be guilty, and I knew coming in when Smith told me today that the verdict was going to be read today. I was like, we talked about this yesterday. That quick turnaround. I was like, I know that 61-year-old woman, Black woman, was like, okay, guilty. Who doesn't agree?
Yes.
You need to. Let's have a private sidebar, because I felt that was what was going down.
Absolutely. Yesterday, Professor Hunter, I was not ready to predict anything, but I talked to my friend Aya, who's also an attorney here, and she reminded me, okay, we had juror number 91, that's who you're talking about, the Black woman in her 60s. We also had juror 52, who I, from the beginning, knew was not going. I knew he was not going to acquit. So unless we had a hung jury, I knew there was going to be some conviction in there.
But it only takes one, though. It only takes one, and 6 white people.
It only takes one for a hung jury.
Well, it only takes one for a non-conviction, and 6 white people, and 6 white people who let off the guy who killed Philando Castile. I didn't have a whole lot of faith in 6 Minnesota white.
Yeah, but one for a hung jury. if you have 11 people who want to convict, but one who doesn't, then you have a hung jury, a mistrial. You don't have a non-conviction.
Well, that's again, a mistrial is a non-conviction.
Exactly. Well, yeah, okay.
In the universe in which we saw what happened is my point. And that's
all due respect, though. All due respect, we knew because it was less than 11 hours, it was not going to be a hung jury. So that was my thinking.
Right. I've been on both sides of the short deliberation and the long deliberation. I didn't have faith that 6 white folks in Minnesota was going to do the right.
But so what we're saying though, and this is and I don't know if Drew believes this, but I believe that there's a strength when we show up in spaces.
Certainly.
When we show up, and when you told me it was a 61-year-old Black woman, I know what that energy is in a room.
Absolutely.
Okay. And it supersedes race. So let me just say, those 6 white jurors didn't have a chance. And then who's the brother that juror number one?
I call him the B-52 stealth bomber. I knew Guardier, he was sliding up into that jury. I knew he wasn't going to go for an acquittal. And now listen, I'd be curious to hear what happened back in there.
we influence culture, fashion, music, movies, television, and every space that we go and we show up, I believe, as our full selves, the influence is. So when you told me 61-year-old Black woman, I was like, okay, yeah, them 6 white jurors, they can be racist if they want to. They're going to get gathered. And 100%. It's going to be one of them, big mama energies that is undefeated. Y'all all know, and it's a look. It's not a shoe being thrown. It's a look that will penetrate your soul, separate your bone from your marrow. You all have seen it before. You know what it feels like. And then you got 52 sliding up, who was, I think you were telling us during the question and answer period where they're eliminating jurors, and they both had on the table preemptive strikes that they didn't even utilize. So every person on that jury was acceptable by both sides, right? Because they could have stricken any of them. Mm-hmm. But he was crafty in his answering. If I remember our conversation about him, he wanted to be on this jury, which is a lesson to everybody. We could all get on a jury.
Yep.
All of us.
Listen, Karen, I say it all the time. Black folks need to show up for jury duty. Having been in a jury, and don't do all of the tricks and things that people say to get out of jury duty. We need Black folks in those jury rooms and in those jury boxes. I've been on 3 juries, and I can tell you that it matters. It matters when we are sitting in those jury boxes. I'll give you the perfect example of, I think that when we just even language and having Black folks not be trusted, right? Like I remember watching the R. Kelly documentary, and where they had one of those white male jurors who said, I didn't like the way the victim, I didn't trust her because of what she had on. I couldn't understand everything she was saying or all of these things, right? He didn't listen to the content of what she had to say. He made all of his judgments about her character and her truth based on what he could hear in her accent and her clothes. That's why we have to be there, so that when we see those folks, going back to the Trayvon Martin,
young sister, her accent.
That Trayvon Martin trial. That's our little sister. We would have seen that young Black woman and said, I know her, right? She might not be using the King's English. She doesn't want to be here. She might not sound the way what somebody else may say a credible witness sounds. But the difference between her being heard and believed and the benefit of the doubt for us oftentimes hinges upon whether or not somebody looks like us is sitting in that jury box.
That's 1000% true. And you cannot quantify that by statute or by forcing jury diversification and so on. You know what I mean? You can't quantify that, but we know it, and we know what our presence there means.
Absolutely. Absolutely. And there were some racial dynamics that came up in this trial. I think now that we're at this juncture, it's fair to put all that on the table, and the court needs to reflect on itself, because
do tell.
Jurors, they make those judgments, as you just so elegantly outlined. So do judges. And I think I saw repeated instances in this trial where Judge Cahill monitored more stringently the Black witnesses, where he entertained objections to Jerry Blackwell, the Black attorney, and where objections were drawn from counsel for the same conduct that the other white attorneys exhibited only against Jerry Blackwell. Those things need to be talked about.
Let me ask you, his commentary from the bench, which we played on these airwaves, regarding Maxine Waters, who was taken out of context regarding this trial. I thought it was really weird that he would do that from the bench and name her by name, and then call and say you have a case for a mistrial or for on appeal or something to that effect. You have a case for appeal. What was that? What was that, Professor Porter?
It was the last in a litany of Judge Cahill littering the record with appeal fodder, to be honest. And I was struck by that as well, that he would call out Maxine Waters specifically when this case has such global import that many public figures have been talking about it. And I thought he did a lot of railing that was just gratuitous. He could have generalized and said, yeah, I think public figures need to be careful about what they say. I mean, that is sort of the repeated theme that we saw come up during voir dire as well. But it just read so bad. It read so biased. And I don't even think he's aware of how that came across. And he needs to be held to account. He needs to examine himself, because this is not the time or the climate for that sort of gratuitous dicta, we call it, on the record in a case like this.
Who could check him? Yeah. Who's responsible for checking him?
There are judicial complaints that come through from regular old people like me and you. And so that's something we're looking into here. But I also think the court of public opinion, the media, is equally, if not more powerful in addressing that sort of thing. So the more we make that a topic, the better. Legal practitioners should be doing that as well. So we'll have to think on that, but it definitely needs to be a subject of conversation.
Angie Porter is here. You can follow her at Angie, ANGI, Marissa, MARYSSA on the Twitters. Don Calloway is here. DC, STL for Don Calloway, St. Louis. He's repping that. And of course, Drew McCaskill, Morehouse owned Drew McCaskill is in the building, crisis manager. Where do we go from here? So we have sentencing. We know that's going to happen. 45 years, 20. I think they should run concurrently or consecutively. I think they should run one after the other. 10, 20, 45. Cahill is going to be delivering that, right? So he's responsible for doling out the time. We don't trust him right now. I don't.
Yeah, I mean, this is actually where the sentencing guidelines, as much as, in some situations we might despise them, work in our favor, because we at least know he can't downward depart from the recommendation. However, Professor Hunter, you and I walked through this already. We know what the guidelines sentence is ostensibly. For second degree murder, it's 12.5 years. For third degree murder, same. For second degree manslaughter, it's 4 years. And
wait. Where am I seeing 40 years for and 25 and 10? Where are those numbers? I need to hear those numbers.
You're seeing that in the law books, in the actual statute that pertains to these crimes. But that is the statutory maximum. And so how we get to the recommended sentence right off the bat, it's a combination of the severity of the crime, and there's a table where you match that up with a defendant's criminal history score. Now, someone like Chauvin, I bet, has a criminal history score of 0. Not sure, but I'm guessing he does.
No, he had other, and they couldn't bring them in. Didn't he have other?
Well, yeah, he had other complaints from citizens, but that's definitely not a criminal history. Big difference.
Yeah. So his complaints that were lodged at the department where he violated department protocol, that's not going to necessarily be a crime.
So what you're saying, Professor Porter, if I could take us back into the pessimistic place, the sunken place, if you will.
Yes.
What you're saying is that there's a very realistic chance that if you give them the max on the most severe charge and find no aggravating factors, the max on the most severe charge plus the max on the other charges, all to run concurrently, we could see a 12-year sentence.
Absolutely. Now we know that the state has moved to submit aggravating factors. We know that they intend to do that. And so that's how you get higher in the recommendation. Right. Don't know if Cahill will go for it. We're gonna have to watch and see. But a couple of the aggravating factors off the top of my head are the crime was committed in the presence of a child. We know that that was brought in at trial. We had a 9-year-old bystander. Also, if the crime was committed with particular cruelty, that's another aggravating factor. And I think they might try to go for that. So we'll see. We should watch sentencing. It ain't over. It ain't over.
With 12 on the most serious charge, and then I think you said 4 and 3, or what were the others?
12
and 4.
Both murder charges.
Okay.
12 and a half.
So in theory, going back to Karen's point about consecutive versus concurrent earlier this show, the max we could possibly get out of this is 28 years.
Right, but I wanna temper it because the presumption is that sentences run concurrently.
That's right. Right, not consecutive. Yeah.
Not consecutive.
So, yeah, even if you break from presumption and find aggregating factors, the most we're going to get is 28. It'll probably be significantly lower than that.
Probably.
So it will probably be 12, and that's at finding the most aggravating version of the worst charge, and they're run concurrently. It'll probably be 12 years.
Well, we start at 12 and a half. If they get their aggravating factors in, it goes up.
Okay, got it. Okay,
yeah.
Cool.
So
12 and a half is the floor.
12 and a half is the floor.
Okay.
Kind of, yeah. I mean, we'll see. We'll see what comes in. 12 and a half is the guideline sentence. So in order to get below, he would have to look at mitigating factors.
Yes.
Now, I'm sure defense is going to bring in some mitigating factors. They're going to try to do that. And that's what you pay your defense attorney to do. So who knows where we'll end up, but we should all be watching it and talking about it.